So in the PMA context, consider the case of a private religious organization, a church specifically, that maintained its right to establish membership criteria despite conflicts with public accommodation laws. The courts recognized the organization's associational autonomy as a constitutional protection. So remember, if you have a church, you don't have to submit a certificate of occupancy or anything like that. You don't have to pay property taxes. In most cases, you don't. Specifically in the state of New York, if you have church-owned property, you don't have to pay property taxes. But you better believe that if you have a church or a religious organization, you get maximum protection. The Cook Islands Trust represent an interesting example. These trusts have established remarkable asset protection capabilities by operating under legal systems that strongly protect trust autonomy. In the international context, when Iranian militants seized the U.S. Embassy in Tehran in 1979, the International Court of Justice ruled that diplomatic premises are inviolable, even in times of conflict, affirming the autonomy and protection of diplomatic missions. And in 2002, when the International Criminal Court was established, the United States negotiated bilateral immunity agreements with numerous countries to protect U.S. personnel from ICC jurisdiction, demonstrating how sovereign nations maintain autonomy even within this international body. So what we see across all of these examples is that privacy and autonomy aren't just operational preferences. They are essential characteristics that enable these organizations to fully function. Private membership associations need autonomy to serve their members' specific interests. Trusts require privacy to protect beneficiaries and assets, and international organizations need immunities and privileges to operate effectively across sovereign boundaries.